The legal consequences to a seller in connection with the short sale transaction are as follows. If a seller is able to get short sale approval from a lender, the seller should also always confirm that the lender is removing any obligation to repay any monies. So while a lender may agree to accept less in order to close, a seller wants to ensure that the lender completely satisfies its debt. That way, a seller is not personally liable for any deficiency that may exist between what is owed on the mortgage and what is accepted as part of the short sale agreement. It's important to retain an attorney to negotiate these items with the lender to ensure that the proper language exists in the short sale agreement and to make sure that all necessary documentation is signed as part of the closing, effectively removing this debt from the seller. What you don't want to have happen is you close on the short sale, but your client who is selling obtains a letter in the mail stating that he or she is responsible for any outstanding balance. If the short sale is agreed upon, and again, the transaction will be contingent on short sale approval, it should be also contingent on complete removal of the debt from the seller. This is the most important legal ramification in terms of selling the property with a short sale and with a lender who may or may not approve the short sale transaction. Documentation to provide to the lenders when preparing to negotiate a short sale transaction are as follows. You should obviously have any payoffs, amounts owed to any lender involved, any line of credit, etc. You should have any statements of account from an association. You should have a copy of the tax bill. Remember, just because a seller is underwater, if you will, doesn't mean the short sale is going to be approved. The lender is going to analyze the seller's position as a whole and determining whether or not to approve the short sale transaction. Seller may own other properties. This is not something that's going to be advantageous to the lender approving the loan. Seller has multiple assets, a lot of money in their bank account, things like that. A lender analyzes everything before approving the short sale. The only factor is not just whether or not the mortgage can be satisfied with the sale of the home. The seller has to be in dire straits in order for any lender to approve the short sale. So it's important that the seller be aware that just because they owe more money on the mortgage than what the home may be worth, you can't really enter into a short sale transaction because, again, a lender is going to analyze the seller's complete portfolio, if you will, in terms of anything owed, any amounts they have, and any assets owned by the seller. Legal consequences to a buyer in a short sale, really, there aren't any legal consequences. The buyer, procedurally, it works the same way. You're going to perform inspections, do a title search, and so forth. The idea of a short sale transaction is that while contingent on short sale approval, it does not affect the buyer's title to the property. So procedurally, it won't have any effect on the buyer. It won't diminish a buyer's ownership. It won't adversely affect the title that the buyer obtains at closing. Every lien, judgment, any adverse factor affecting the current owner of the home is going to be satisfied as part of the short sale transaction. So a buyer will obtain clear title, really has no legal ramifications to the buyer moving forward. Once you close, any deficiencies with the title work are satisfied and everything is up to date and up to par for the buyer to move forward.